heard application and appeal in the matter of Deutsche Bank AG and Vic and another.
Yes, Mr. Sweatherick. Can I just raise one matter that arises out of yesterday? We looked at what Lord Justice Gross said about what happened at the end of the hearing before Mr. Justice Cook, and also what the judge said at paragraph 98. And I think I inquired in one or other context whether we had a transcript of that, and you're about to produce it, are you?
We have it, I brought it, or the relevant part of it, which I will hand up at the appropriate moment.
Thank you very much.
My lords, my lady, before I set out the scheme that I propose to approach or adopt in making my submissions, just a short point that arose at the tail end of yesterday in relation to ground 3. There's been some back and forth overnight and this morning. I understand that there is an issue or possible issue about whether or not certain documents can be referred to in the context of ground 3. I'd mention it now. If it is going to be an issue, it'll be addressed in the context of ground 3. Hopefully some progress can be made over the short adjournment, but I said to my learned friend I'd mention it so you know it's a live point.
All right, let's
it's no longer alive.
see where we are when we get to it.
Quite, my lord. So, subject to your views, I was proposing to address the issues in the following order. First, I propose to say something very briefly about the background. Next, I shall address the bank's ground 1, which is the question as to the court's power. And as you know, we say the judge was correct to conclude that she had no power to make the order sought. And we say further that there's an additional point, which is the effect that there is no power to order the examination of an officer of a judgment debtor or to summon a person in a position akin to a witness for a fraud. And we've raised that via the respondent's notice because in light of the judge's decision on the first point, she didn't need to deal with it, so we've raised it. In the context of dealing with ground 1, I will attempt to deal with the queries that were raised by the court in the email sent on Monday afternoon. I may take those quite early, actually, just to clear the ground, so to speak. I next intend to address you on the bank's ground 2, which is the discretion question, and our respondent's notice point that the order isn't sought for a proper purpose, and that will be ground 3, for which Mr. Hampton will address you upon.
Yes.
If I may then, a preliminary point or two regarding the background. There is a theme or a premise running through the bank's submissions that there must be a power to make the order that it seeks. It said at paragraph 56 of my learned friend's skeleton argument that the practical effect of the judge's decision is to denude the court of power under the inherent jurisdiction to make orders protecting its capacity to ensure compliance with and enforce its own processes. In my submission, it's appropriate to recall how we've arrived at the position that we're at. Now, the power to order examination under Part 71 is a somewhat unusual power. It's one that's limited in its scope and application. As it was put by Lord Mance in Masry number 4, it was a product of energy and pragmatism of the Victorian era. What it effectively has done is it required Mr. Vick to provide assistance to the court. And when it imposes obligations upon a director to provide information, and if such an order is properly made, if that officer breaches the order, then the order will be faced with contempt proceedings. And that is the case whether or not the officer has ceased to be an officer of the company. That's whether or not the individual has left the territorial jurisdiction of the court. That's what the Court of Appeal held in these proceedings. As I'll come on to in a moment or two, there's also the option of adjourning the examination, specifically catered for in Part 71. Now, in our case, and it's relevant to my Lord's query regarding what happened at the end of the hearing before Mr. Justice Cook. At the end of that hearing, the bank didn't seek an adjournment, although it's recognised that it could do. It said it had completed its questioning. It said it had no further questions. The bank then elected to pursue contempt proceedings, which of course were premised upon the proposition that I don't deny that Mr. Vick had not complied with the Part 71 order. That was the premise underlying the contempt proceedings. So those were brought against Mr. Vick. They went to a final hearing. They occupied significant court time. They succeeded. thus the most serious and powerful weaponry in the court's armoury was available. It was exercised. A sentence was imposed against Mr. Vick. The integrity of the court's processes and the upholding of its authority was protected.
So is it your submission that basically the only thing that the court can do is go via contempt?
Not quite, my lady, and it's the point about adjournment that I'm going to come on to in a moment. Although I do have in mind addressing the point you raised yesterday, is it effectively saying that contempt is the only option available? And on that, I would just note this. Given the particular nature of Part 71, requiring, in this case, Mr. Vick to provide assistance to the court, these aren't ongoing civil proceedings where he's required to take steps which, if he doesn't take them, the court can make unless orders, striking out a defence or anything like that. They're of a different nature. They're requiring him to give assistance to the court. If he doesn't give that assistance, the court can punish him with its most serious armoury.
And that's all it can do.
That's not all it can do. That's not all it can do. As I'll come on to, what it can also do, specifically catered for the rules, at the hearing, if it's not clear, if he's complied or further questions might want to be asked, the hearing can be adjourned.
Well, yes, but you,
Adjourned part, I mean, it can clearly be adjourned before it's heard, and I think that was done in this case. It was moved from September to December. So you're talking about being adjourned part heard.
It can be adjourned at the hearing itself, yes. Yes, my lord. And the effect of that is therefore the continuation of the obligation, the continuation of the order.
But is it a necessary part of this submission that contempt proceedings have as their sole purpose punishment rather than in order to encourage compliance with the order?
It's not a necessary part of it, my lord, no. Because what I will come on to is, and it's an important point that was touched upon yesterday, is the nature of the specific order in this case and the distinction to be drawn between orders which have impose a continuing obligation and an order which opposes an obligation for something to be done at a certain point in time. And where that point in time has passed, then the court can't make an order to say, go back in time and do said thing. My learned friend yesterday made reference about the case involving the father and the daughter. And she said, no, the order we would want is an order that says, don't bring back the daughter when she's 9, bring her back when she's 7. What the court can't do here, and that's why we say it's inapt to discuss the concept of enforcing or procuring compliance with the 2015 order. The court couldn't make an order today saying Mr. Vick shall attend in 2015 to answer questions.
well, no, but it could make an order if it had the jurisdiction saying he should answer the questions that he should have answered in 2015.
My lady,
That's the whole point, isn't it?
my lady, that is what arises under the jurisdiction. Well, we say no, he can't. The court can't do that.
Yes,
It
you
could
do,
do it
but-
under the contempt jurisdiction, of course.
Yeah, but the point that my lord has made, which it seems to me is a valid one with respect, is that contempt proceedings are designed to get somebody to do something which they should have done and didn't. And at the moment, your submission seems to be, well, the contempt proceedings wield a big stick so that you're encouraged to do what you should have done under duress, effectively, of going to prison if you don't do it. But that's about it. What the court can't do as part of its armoury is say, you must now do what you should have done already. And I don't understand at the moment why the court can't do that.
Our submission, because it doesn't arise under the jurisdiction relied upon. If Mr. Vick remained amenable to an order under Part 70.2, a new order could be made. 71.2, sorry. What's being done here, of course, or what happened here, was an order was made. The order was made against Mr. Vick, saying, upon findings that you have breached the order, you did not do that which you should have done. And as part of the sentence was a condition of the suspension of the sentence, Mr. Vick was required to do certain things. And in fact, the nature of the conditions was a new examination. So what the court was able to do was to procure the things, what you might say is the purpose, perhaps underlying the order as originally made. But in my submission, that is different to an order that says you must now do the very thing that cannot now be done. Because the premise, of course, of contempt is that it has been a breach, it hasn't been done. And this is an order slightly jumping ahead, but I'll mention it now. This is an order requiring someone to do something by a fixed point in time, as opposed to a continuing obligation, such as a freezing injunction which says you must not dissipate your assets below a certain value. Where it's an order to do a thing by a particular time, in order for there to be the ability to bring contempt proceedings, there must be a particular time, and that must be breached. Because if it is an order that says you must do something, if there is no time, there can't be contempt to it. That's why there has to be an order for a particular time. So in a different situation here, and in that circumstance, what I learn in Friends seeks to do is then say the jurisdiction, which we'll come on to make orders to assist in procuring compliance with the first order, the provisions or the obligations in the first order, which here was to turn up in December 2015 and answer questions before the judge, doesn't arise. It's conceptually different. What in substance would be making is a new order requiring Mr. Vick to turn up at a new point in time to answer questions afresh.
Does it follow from that you'd make exactly the same permission if he'd never turned up at all?
If Mr. Vick had never turned up at all,
Yeah.
the court would have adjourned the examination, so the obligation never would have come to an end.
Suppose he
Well,
didn't.
I thought you were submitting that it was an order that something should happen
Yes.
at a particular time.
Yes.
And once that time had passed and it hadn't happened, he might be in contempt. But you need a fresh order to order him to do something at a subsequent stage. Is that, if I misunderstood your submission?
If you don't seek the adjournment, because that's what's catered for. What is catered for is the ability at the hearing to adjourn it to another date. So that continues it.
So that means that there is a difference in quality between a situation where, let's say, it's obvious on the day that somebody is being recalcitrant, shall we say, and they don't, and therefore the powers of adjournment are used to put it off to make sure that the information is complete. And a scenario where it appears they've answered the questions, and then the next week a whole heap of other documents come to light which shows that they were lying through their teeth. Now, in the latter, on your submission, on the latter scenario, the only thing that the court can do is seek a fresh order.
Or contempt. Breach of the first order. And that's why and that goes back to the particular nature of this jurisdiction. Mr. Vick is required on the date to turn up and answer the questions there. If they don't ask questions there, that's a matter for the...
But on both those scenarios, they haven't, all right? One scenario A, it's obvious they haven't, therefore you adjourn it. Scenario B, it's not obvious, but they still haven't done it. In each case, what they haven't done is the same thing, exactly the same thing, but you're saying that the court's powers depend on whether you find out that they're lying on the day or later.
Or suspect, my lady, because a party can seek the adjournment at the examination.
Can I ask, I'm just looking at the order, Mr. Justice Tier's order.
Yes.
It's got three substantive obligations. One's to turn up and attend a court on
Yes.
the date. The other is produce documents 14 days prior. And the third is to answer on oath all questions which are asked.
Yes.
We know that Mr. Vick turned up. When he was committed, we haven't really looked at the detail of this. Was it for failure to produce all documents, or was it for failure to answer all questions, or was it both?
Both.
It was both. Because if we just focus on failure to produce documents at the moment, I mean, I see the point that if your obligation is to answer all the questions that you're asked, then all the questions have been asked, and you either answered them or you haven't. And there's no scope in that to ask. Your submission, there's no scope once that's, unless you adjourn it, to say, well, you haven't answered the question, now I want to ask the questions again. But with the production of documents, it's very, very common. There's nothing special about Part 71 for somebody to be ordered to produce documents. And it's very common for people not to do it within time. It's absolutely routine to say, well, you're in default of your obligation to disclose documents, and we're going to set a new time for you to do the same thing that you haven't done. in a normal case. There's no difficulty about that at all. But you say there is a difficulty in Mr. Vick's case.
In the particular case of the application that's being made, which is to examine Mr. Vick, not for production of documents, there is, and it again, it comes on to a point I was going to get to, my lords. My learned friend yesterday suggested what we could rely on Rule 3.1a, 3.12a, how to extend time for compliance with the court order. But let's think about that. How to extend or shorten time for compliance with the court order. If we take this example, if the time for filing of a defence is extended, the claimant cannot rely upon the prior failure to provide it by the original date. So there's been an order and that's extended because the effect of the extension is to vary the date. So you can't rely upon the prior breach. If my learned friend now says, and I've got much to say about the idea of varying the application below, which I will come on to in these circumstances, if we were to treat Mr. Justice Tier's order as being varied now, the date for questioning, shall we say, that is in the context of there already being an order for committal on the basis of breach of that order. We extended, we've increased the date of it. He no longer has been in breach of it. The entirety of the contempt proceedings become written out of history in that sense. It's conceptually extremely difficult to see how that could work. That's a particular issue here. But of course, isn't enough anyway, because as my lord has identified, there's multiple obligations. This is actually an order to attend a hearing, and you'll see actually in part 71 it says the court can make an order requiring the person to attend court. It's not sufficient to just vary the date, because if you were to take the example of bringing the date sooner, so he must provide it by the let's say the 1st of December 2015, the measurement was made, you still need to bring the hearing forward. Likewise, an order which my learned friend said you can make yesterday to change the date in here to say that he must attend on the 28th of October, you do need to also extend the hearing. Because this is if a party doesn't attend a hearing, you have to adjourn it or something else. You can't do, in my submission, retrospectively adjourn a hearing that has been completed, not been continued. Can I, because there's a number of points which I'm going to try and collect as I go.
We've burned you off course.
Yes, I'm sorry.
No, I'm grateful.
I would like at some stage to focus on the particular obligations, because
Yes.
I think it may be different answers to, can you be required
Yes.
to attend again? Can you be required to produce documents again? And can you be required to answer questions again?
Yes.
But I don't want to take you out of your course. So
I'm grateful.
when you get to it, get to it.
Yes. So where I got to in terms of the brief word on the context was I made the point the sentence had been imposed, the court's most powerful sentence, power had been exercised, and so as to uphold the integrity of the court's processes and authority. What happened then is extraordinary. As Mr. Justice Henshaw held, the bank failed to activate the sentence in accordance with the mechanism and the order. It slipped from its grasp as it was put by Mrs. Justice Cockerell. Now, the bank sought to challenge that, but as Lord Justice Mayles held, when refusing the bank permission to appeal, what the bank was seeking was not merely the correction or variation of the committal order made by Mrs. Justice Mulder, but the making of a new and more onerous order after, on its true construction, the order had expired. And he said, you see no basis, this is in the order which we've got in the bundle, if you want to see it, it's a supplementary bundle, tab 21, page 161. He could see no basis on which such a new order could or should have been made merely because the applicant had misunderstood the effect of the order made by Mrs. Justice Mulder. Now, my submission, what that exposes contextually is that the bank's difficulty is not the product of some shortcoming in the scope of the court's powers. It's the consequence of the fact that the court, having given the bank the tools to enforce the Part 71 order, having made the Part 71 order in the first place, those not fully utilised for the reasons we now know. Now, Lord Justice Gross noted in the Court of Appeal decision in this case that there can be a tension between enforcing court orders on the one hand and keeping the jurisdiction of the court within its limits. Mrs. Justice Cockerell in this case made a similar point to paragraph 70 of her judgment, when she noted that the jurisdiction under Part 71 is limited, and however much the court may want to ensure that its judgments are observed and satisfied, there are limits to what can be done within the rules. The corollary, of course, is limits to what can be done out with the rules. It's the nature of those limits which we're exploring. So ground one. An elementary point on perhaps terminology, and I recognise it's incredibly elementary, but I'm going to make it. The word jurisdiction can be used in multiple senses, and there's perhaps a need to keep that in mind. I'm going to use the word power, and I think that's how we've used it throughout our submissions, because the issue that arises on my learned friend's ground one is whether the court lacked jurisdiction in the sense of power to make the order that they're seeking. That is different, as the court knows, of course, from the concept of in personam jurisdiction. The fact that a person is within the territory of the court and so subject to its in personam jurisdiction does not mean the court has free rein to make whatever order it wants against that person. That's self-evident. That's made clear in the Beckel case that we saw yesterday. We have laws, we have rules. And again, a party might properly be served with the claim out of the jurisdiction in which the claimant claims certain relief. But the fact that there has been service and the court has jurisdiction over the person for the purpose of the claim does not mean the court then has the power to make any order that it wants. So that's just the point on terminology. And I think it's useful because there were times, particularly when we come to the decisions which my learned friend submits our support for the proposition that the court's previously shown that it can use its inherent authority to make the same order again. There was perhaps at times a tension between, or sometimes not a clear demarcation between the manner in which the word jurisdiction was being used. The Part 71 order, as my Lord Justice Nugee says, is important that we look at it. And as you've seen, it's a tab 16, supplemental bundle, page 136. It was an order that required attendance at a specific date, at a specific place to be questioned. Also an order to provide documents in advance. And per paragraph 3, the officer, that's Mr. Vick, at the time and place was to answer on oath all the questions which the court asks, which the court allows the judgment creditor to ask. And there's a penal notice, of course, at the bottom. You must obey this order. If you do not, you may be sent to prison for contempt of court. Now, there was some discussion yesterday as to whether the order was extant or spent. My Lord Justice Nugee asked my learned friend what was meant by an extant order. My learned friend said it's still a live order because it's not been spent through his compliance. He knew he had not complied with it, is what I mean. In my submission, using terminology of extant, live, spent, somewhat unhelpful, somewhat circular perhaps. Perhaps I'd submit a more helpful approach is to consider, as I've noted already, whether an order imposes continuing obligations or impose an obligation to perform or do certain things at a fixed time. And an order, as I said, or a freezing order is one that imposes a continuing obligation. So if a respondent to a freezing order disposed of asset 1 on Monday, contrary to the order, that would be a breach. If they dispose of asset 2 wrongfully on Tuesday, that would be a breach, separate and independent breaches of the order. Contrast, in my submission, the order we have here. It required Mr. Vick to attend on a specific date to answer questions, to provide effectively information at that time. If he hadn't attended on that date, he would have been in breach of the order, could be subject to contempt proceedings for that breach, just as much as has been held if he did attend but did not answer the questions truthfully. But where one is dealing with, as here, an order requiring a positive act, as we say, in order for there to be contempt proceedings, there must be breach by failure to comply by a specific date here. Now, the breach, therefore, was on 15th of December 2015. It could not be said in my submission that Mr. Vick was in breach of the order on the 16th of December 2015, as in there was a new breach, nor that there was a new breach on the 17th of December 2015 going on. It's a once and for all breach. It imposed obligations that were time limited in the sense of you must do it on this day. It does not impose an obligation upon him to keep coming back to court every single day to answer questions. And you have the point that I've made. The premise of the contempt proceedings, of course, was that he did breach the order on that day. And he was held to be in contempt for having failed to comply with the order, failing to have delivered documents as ordered, or to answer questions truthfully as required. So we say it's inapt to speak of procuring compliance with an order that required compliance in the past. The court, as I've said, clearly couldn't make an order now that Mr. Vick shall attend on the 15th of December 2015, just as much as it couldn't make an order saying to the father, now produce your daughter 2 years ago.
But that is the language that's often used in the sentencing context for contempt, where the jurisprudence says one ought to identify what aspect of the sentence applies to punishment for past breach and what is to encourage future compliance with the order. That's just wrong, is it?
No,
to talk about future compliance with an order, which is an order to provide an affidavit of assets in support of a moreover injunction by a particular date.
I don't say that's wrong as a description of what the court is doing, but in substance, though, it's different by saying you must now do this thing by a certain date, effectively giving a new date, failing which you are going to be punished for the breach you've already committed, as opposed to saying, I'm now going to make a new order to you today to do this thing. Because that is creating a new obligation as opposed to penalising the old one.
But suppose in this case that it's simply been not a suspended sentence encouraging further attendance to answer questions, but a sentence of imprisonment which said 6 months for past breach and further 6 months to encourage compliance. Would that have been a sentence that was available on the committal application? I mean, in principle.
Yes.
Forget the numbers.
Yeah.
And what would then be meant by compliance on your case? Because on your case, there wouldn't be any further compliance. The court wouldn't be ordering any further compliance. It would only be compliance with the order which had previously been made. I mean, I think you would have to say, don't you? Actually, the court couldn't do that when sentencing because further compliance is an inept concept at that stage.
I wouldn't say that, my lord. It's a matter of language. I'd say that what the court is doing is saying part of your sentence is to encourage that you now do that which you should have done in the past. So effectively belated compliance, you might say. But that is different to my submission qualitatively to actually saying that this is now requiring you to actually do the thing in the past.
No, I entirely accept that. But if it is to encourage you to comply with something,
yes,
the premise is that there is still something for you to comply with. And I think your argument is that after the date's finished and the questions have been answered, there is nothing for him to comply with in the absence of a further order that he attend on another occasion to answer questions. That's my conceptual difficulty. I don't know if I'm expressing it clearly enough.
You are, my lord. It's me who's not expressing my answer. Well, it's my submission. It's a matter of language rather than a matter of substance as to what is happening there. The order that's made, the rationale perhaps for the sentence is to encourage the thing to be done, if I might use that language. Hopefully that's unobjectionable. But in my submission, analytically, that doesn't mean that there is a subsisting obligation under the original order. And of course, as I've said, the premise of the contempt is that the obligation has been breached.
Can I try and posit another example, get away from Part 71, which you say is particularly good. And suppose there's a trial and an injunction is granted which requires the defendant to do something positive, build a wall. And the court fixes a date, 4 months, 4 months passes, wall's not being built. That's a breach. Now, you're plainly right that you can't say that if it has to be built by the 1st of January, but on the 2nd of January, you've again failed to build it on the 1st of January. You failed to build it on the 1st of January, that's your breach, and you can be committed from it. But suppose the claimant then goes to the judge and says, look, the defendant's not done it by the 1st of January. We're in a position to commit, but we don't really want to have a full-scale commitment. What we want is we want the wall built. So will you now please set a new date and require the defendant to do it by the new date? The court can and normally would do that. It doesn't seem very, it doesn't seem wrong to say what the court is doing is ordering you to comply with your existing obligation, which you failed to comply by the original date, but you still haven't done it. So we're gonna order you to do it by a new date, and it's still the same obligation, isn't it?
My lord, the question actually arises is to what is the power that the court is exercising. And what we say it's doing there is exercising its own original jurisdiction to make an order to build the wall. It's hard to imagine a particular scenario other than this case, but if the court makes a danger doing examples, but I'll try. If the court makes a freezing injunction, but a prior to injunction is probably a better one. Court orders an injunction against defendant's asset A. If the claimant then wants to get, because they establish some basis to get a proprietary injunction against asset B, the fact that the court has made an injunction against defendant already doesn't mean that you don't have to establish there's a power to make a freezing injunction or a proprietary injunction against asset B. You have to establish it. Again, you have to establish the basis. The court's made a freezing order to say against all of the debtor's assets, and let's say that it was domestic only, and an asset disclosure order. So it makes the injunction on the 1st of January, get the asset disclosure on the 15th. It discloses some assets in Greece. If by then, for some reason, and this is our case, the power to make a freezing order has gone, you couldn't then, in my submission, say, I now want a freezing order against the foreign assets because I previously got a freezing order.
But can I just go back to my lord's example?
Yes.
Suppose in his example, the court had assumed jurisdiction originally on the basis that the defendant submitted to the jurisdiction and participated fully in the trial and resisted the injunction and failed. Is it your case that when it got to the further order, that having failed to build the wall by 4 months, he could say, well, you don't have any jurisdiction over me. Now I know I participated in the trial, but this is now exercising a new and original jurisdiction, and I don't recognise the power of the court, the jurisdiction of the court to do so.
No, not at all, my lord. And that's the distinction between in personam jurisdiction and power. So what I would say is, and this is what we see in the cases where successive orders are made, if the court has got power, has got jurisdiction over the person to make orders against them, it can make the order, it makes the first order. If it's going to make the second order, the question isn't whether there's been service of process, it's a question whether the court has the power to make it. If the court has the power to make an order requiring the person to build a wall, the court just makes that order. Now, there's different ways you might analyse it. In my submission, that's just exercising the power that already exists, nothing to do with in personam jurisdiction. The court, even if you've got in personam jurisdiction, the court needs to have the power to make the order.
Well, I understand you say there were two stages.
Yes.
You need both the power and the territorial jurisdiction. But and at the moment we're just on the power.
Yes, and on the second.
But in the example that we're putting to you, where does the court's power to do it come from?
Whatever power the court had to order to protect the claimant's right, I suppose, to order that you build a wall, that still exists. And so you're just exercising that power. What you're not doing is varying. I mean, concede there might be circumstances in which, where you say analytically the court is varying its previous order. But that's a different thing. That's not then exercising inherent jurisdiction.
It seems very odd to say you're exercising a new inherent jurisdiction and exercising a new power. So what you're really doing, and what everybody would understand you as doing, is saying you were ordered to do this, you didn't do it in time. I'm going to give you another 2 weeks or 2 months to do it, but if you don't do it this time, then you're at risk of being sent to prison. That happens every day, up and down the country, in every sort of court, and it's entirely regular. And nobody ever thinks that what you're doing is exercising some new, fresh jurisdiction. You're just requiring the defendant to do what they've already been ordered to do and giving them an extra time to do it.
And if you have the power to do it, then that's absolutely fine. But the issue that arises here is the question whether the court has the power to do it again. On your example, my lord, if what the court is actually doing, because it's formulated this way, is varying its earlier order, then that is meaning that there was no longer going to have been a breach of the order because you're varying the order. So that's different, of course. That's not exercising the order afresh.
But the court must be able to say, you are in breach. And nothing I now do is going to take away the fact that you're in breach. But I'm going to give you another opportunity to do what you really wanted to do. And I have to say that looks to me like not so much varying the original order, but giving the opportunity to the defendant to comply belatedly, as you said, belated compliance with their existing obligation, not so much imposing an entirely fresh obligation, but just extending the time for compliance of your existing obligation. And as I say, that's how one normally would think of what the court is doing, and it's a very, very familiar thing. There's nothing odd or recherche about doing it. It happens all the time.
But it's not available here.
Well, that's the question.
Because-
Why not?
Well, for one thing, because Mr. Vick has already been punished for the breach of the order in December 2015. So if the court were able to now vary or extend that order, leaving aside the question of relisting a hearing, that meant he didn't breach it. But the bank is then playing ducks and drakes or blowing hot and cold. It can't do that in my submission. That's why it hasn't. So it's not made that application. It's not open to it, I'm going to say, to make that application now anyway. So, what we say, it's slightly repetitious, the reality of the position is that the order required Mr. Vick to do something on a date in December 2015, in terms of the answering questions. That was the time for compliance to attend court and answer. The court has found in the context of contempt proceedings that he did not comply. The time for compliance of that order has been and gone. He cannot be ordered now to comply with an order that required compliance in December 15, in the sense of making a new order to say do it in 2015. So if the order sought by the bank was made, it would require him to provide information at some fixed new date in the future. And in our submission, in no sense is that procuring compliance with the 2015 order. And the question that my Lord Justice Popplewell put to my learned friend yesterday is, what's the scope of the questioning under the new order? And that, in my submission, helps to expose the problem. My learned friend can't say, in order to ensure that this order, which required Mr. Vick on a date in 2015 to provide answers, can't say that the new order would only be limited to him doing that, because then there'd be no utility in it. So my learned friend has to say that the new order imposed an obligation for him to provide answers on the questions, not just to do that which he was ordered under the 2015 order, but now to provide new information, further information. So it is, in substance, as that exposes my submission, a new order, in quality, in substance, in effect.
Can I just, I'm sorry to keep asking questions.
Yes.
But, an order is made to attend on a certain date. The respondent fails to attend on that date.
Yes.
You say and in the meantime, he's gone abroad and looks as though he's going to stay abroad. You say, as I understand it, that on that date, the efficacy of the original order can be maintained by seeking an adjournment of the hearing date. But I think you say, if there isn't an application to adjourn the hearing date, that's it. The applicants lost their opportunity. Have I understood the consequence of your argument?
Yes, that's what we say. May I address you on the adjournment point then? This arises from the query that the court posited on Monday in the email from the court, where the court posited the situation where the scenario where the respondent to a Part 71 order does not attend and the court considers giving further time to comply, or where the respondent attends but does not provide satisfactory answers. And we say in such circumstances there is power to adjourn the examination hearing, and that's recognised in Rule 71.7. Headed adjournment of the hearing. If the hearing is adjourned, the court will give directions as to the manner in which notice of the new hearing is to be served on the person ordered to attend court. And we say what an adjournment is the continuation of the examination hearing. It doesn't create a new obligation to attend. Hence, of course, the reference to if the hearing is adjourned and giving notice of the new hearing, not to the making of a new order for attendance. So that's one option. And that deals, in my submission, perfectly adequately with the scenario that you raised.
So does it follow that the only form of adjournment that would do the trick is a specific adjournment to a defined subsequent date? Or could the court adjourn what we used to call sine die, but we're not allowed to anymore, just generally to be restored on application? Would that be a sufficient adjournment to protect the applicant? Because 71.7
Yes.
contemplates that it's going to give directions as to the manner in which notice of the new hearing
Yes.
is to be served. So that does seem to be contemplating a specific case in which a new hearing date is fixed, and then it will at the same time give directions. But one can conceive of many circumstances in which the court might think it appropriate to adjourn, but without at that stage being able to fix the new hearing date. Even if it's not a general adjournment, sine die. So I'm not sure 71.7 is a complete answer. Obviously, it recognises that there is a power to adjourn to a new hearing date, but would the position be protected if there weren't a new hearing date fixed?
Well, following my lord's logic, then that's another option as well, which again protects.
It does protect.
Yes.
You could say, I'm told there's going to be a committal. We'll have the committal. We'll see what the position is at the end of the committal, and then you've got liberty to restore in the light of the outcome. That would keep the order alive, if I can put it that way, would it? And it wouldn't matter that when the application to restore took place, it was now 5 years later, and that he'd been abroad for 5 years.
That example then gives rise to questions of whether it would be appropriate to do that, because of course the purpose, this goes back to what a Part 71 order is required to do. It's bringing someone before the court, when it's not the judgment debtor but an officer, to provide assistance. It's not designed to require that assistance to be sort of floating in the air indefinitely, so that the judgment creditor can sort of at its whim decide actually some new thing has happened.
But assume this isn't at the judgment
Yes.
creditor's whim. Assume that it says this at the end of the hearing, says we don't think that he's answered any of the questions truthfully. We're going to take committal proceedings, but we want to reserve the right to come back in due course. He's busy saying, let us assume, no, I've answered all the questions truthfully, and then 7 years, it takes 7 years for the committal to run its course as a result of entirely unsuccessful challenges by the respondent. So one's not looking at it being at the whim of the judgment creditor. One's looking at a case in which the judgment creditor couldn't be criticised. Forget whether that's this case. Assume that's the case. I think you're saying, but tell me if I'm wrong, that would be sufficient for the court to be exercising the same power that it was exercising in the original order when it was restoring it 7 years later. Have I misunderstood that?
Where I would, if I may, slightly quibble is the suggestion implicit in my lord's question that what the judgment creditor could do is, if there's a general adjournment of the hearing, is nonetheless go forward in contempt proceedings, pursue those, and then effectively bring back the hearing later on. And I'm going to take you in a moment to the discussion for Mr. Justice Cook at the end of the Part 71 hearing. If the respondent attends a hearing and the examination is adjourned, in my submission, it would be conceptually difficult, if not impossible, for the respondent at the same time to be faced with contempt proceedings. I say it for this reason. If you're asked a question at the examination, and you answer it, and the debtor or the officer originally doesn't answer it or answers it untruthfully, but then later on in that same examination is asked it again and answers it truthfully, as which you're not going to able to bring contempt proceedings for the answer to question 1. Because whether you analyse it as purging or whatever, it's been addressed. If there's the continuation of the obligation to be examined to answer questions, that means that there is live exactly that same scenario where the question, if asked again,
well, sorry, but I'm not sure the first point is sound, is it? When you purge a contempt, that's relevant to the sentence for the contempt. It doesn't remove the fact of the contempt taking place, and it may, in some circumstances, be appropriate that some form of punishment is visited for the past contempt, even if it's been purged in the sense of remedied.
Well, in my submission, that's impermissible. It's impermissible for a party to be pursuing contempt proceedings for breach, where at the same time they're seeking in parallel, effectively, or subsequently, to bring back the same obligation, to reignite the same obligation when they're having relied upon a breach of it.
Why? Because the objective is to actually get the person concerned to answer the question truthfully. And what you're postulating is that you've got to make an election. You either try by means of an adjournment and having another go, or you pursue them for contempt, but you can't do both. And at the moment, conceptually, I can't understand why you can't.
In my submission, actually, that you could seek the adjournment whilst you consider whether you're going to go down the contempt route. But if you then decide to go down the contempt route, that is your election.
But why is there an election? Why is it that you can't both use the mechanism of contempt, both to punish and to encourage somebody to comply, and get a court order, or get the hearing adjourned with exactly the same aim in mind?
My submission is akin to seeking inconsistent remedies. On the one hand, you're seeking to punish the person for the thing that they didn't do,
And to get them to comply.
and to get them to comply. But then, if you then, having done that, and let's say you failed, it would be completely inappropriate to then say that you're able to have this examination again.
So effectively, the person that you're seeking to comply can basically just stonewall and do absolutely nothing about it. And the person who's trying to get them to comply is powerless.
Not at all, my lady, because of the contempt route in that case, that's the obvious route that you'd go down. You'd say, right, and may I actually show you 71.8. Sorry. Failure to comply with order. If a person against whom an order has been made under Rule 71.2 fails to attend court or refuses at the hearing to take the oath or to answer any questions or otherwise fails to comply with the order, the court will refer the matter to a High Court judge or a circuit judge. The court may, provided the judgment creditor has complied with Rule 71.4 and 5, hold the person in contempt of court and make an order punishing them by fine, imprisonment, confiscation of assets or other punishment under the law. If such an order is made, the judge will direct that the order shall be suspended, provided that the person attends court at a time and place specified in the order and complies with all the terms of that order and the original order. And if the person fails to comply with any terms on which the order is suspended, they shall be brought before the judge to consider whether the order should be discharged.
Comply with that order and the original order.
Yes.
But he can't comply with the original order in the context we're talking about, because on your case, that's only an order to do something on the date in December.
Yes.
And there hasn't been an adjournment because you say you can't. You can't adjourn it and you elect to go down the contempt route.
Yes. And what I say is, though, is this demonstrates that this is the other option. Now, there are extraterritorial questions about it, but what this reinforces is that you don't have a twin-track procedure. You don't have a twin-track procedure where there's going to be continuing examination, whilst there's also going to be orders requiring attendance at court to have effectively the same examination.
But there may be cases in which that's obviously the sensible thing to do. Take a case in which there is a genuine dispute about, let's take documents, but the same thing could happen in relation to answering questions. There's a genuine dispute as to whether the document is one which the party is in a position to procure production.
Yes.
And that may raise some quite complicated questions. And he says, I can't get it. And the applicant says, yes, you can. And the applicant says, and I'm going to bring contempt proceedings. And as we know, contempt proceedings don't require an intention to breach the order. They simply involve an intention to do that which objectively judged is a breach of the order. So then there's a contempt hearing at which the circumstances are all investigated and the court held, yes, this was a document under your control. You were obliged to produce it. Is your submission that in those circumstances, by taking contempt proceedings, the party has debarred themselves of leaving open by virtue of expressly asking for an adjournment before doing so? They actually have to elect between one of the two. They can't say, can we adjourn the hearing whilst we have this determined in contempt proceedings, and if we're right, come back and get him to produce the document or get him to answer the question.
Yes, we'd say that's abusive.
Why?
To go forward to try and prove to the criminal standard with the serious repercussions of it that a person has breached an order in a way that should visit upon the consequences of the quasi-criminal jurisdiction.
Right.
Having felt that, say, actually want to have another...
No, having succeeded in that.
Oh,
having succeeded in that, then you say they can't come back and say, now can you produce the document?
But if they succeeded, then as the term of the court sentence, the court can say, you must now produce the document, and that's part of the conditions.
Well, they can't order the production of the document. You can say, I'll suspend the sentence if you produce it, but that's rather different.
Yeah.
But the court can no longer order production of the document.
My submission, no, but if you think about it the other way, if you then go back and get the order to produce it and they don't produce it, how does the court enforce it? Contempt. And if the idea is that contempt doesn't work because it doesn't provide the teeth, then that same objection applies at that level, my lord.
And my fault, I didn't quite follow that.
So if the concern is that going down the contempt route isn't good enough because an order saying you're going to go to prison unless you produce the documents isn't going to procure the documents. Because you must be able to go and get an order that says produce the document. But if one thinks about that, you get an order that says produce the document. If they don't produce it, what then? Contempt. And then you go back into the same question. Is this person going to produce the document for fear of going to prison?
Well, suppose at the end of the contempt proceedings, the court says this was a contempt because on the proper construction of the order, this was a document within your
Yes.
And on all the evidence. But I accept that you had a properly arguable case, and it wouldn't be right to punish you for that contempt, although it is a contempt. But what we do want to do now is order you to produce the document, and if you don't do it now, then you will be punished for what is a subsequent contempt. Court can't do that.
If the court had the ability to make a Rule 71.2 order, then it could do that. But it needs to have the power to do that. That's my submission.
And when you say it needs to have the power to do that, what you're saying is you can't do that if the person concerned is no longer an officer of the company or is outside the jurisdiction. That's the point.
Yes.
That's the substantive point.
Yes, and that is the consequence of the jurisdiction. That is the consequence of how.
What do you mean by that?
That's the consequence of the very limited power that is granted by 71.2.
Now, I think you're on a slightly different point, which was you can't adjourn sine die and have contempt proceedings because taking contempt proceedings is an election.
Yes.
And I'm just still on that
Yes,
point.
yes.
And the example I was giving to you, where there is an express adjournment whilst the contempt proceedings take place, you say is simply wouldn't be open to the court. Because I think you've accepted if you adjourn, that could be an exercise of the original power when it comes back. But the taking of contempt proceedings is an election. And I was on that aspect of your argument.
Yes.
And
Because
why does the example I then put you not suggest that can't be right? It's not sensible to treat the taking of contempt proceedings in all cases as involving an election.
Because the reason you're seeking contempt proceedings is because there's been a breach of the order. So you've finished the hearing, so the hearing's been completed, in my submission, and he hasn't provided that which he was supposed to do at that hearing. So you're bringing contempt proceedings in respect of that. So then at the same time, you're saying you're adjourning the hearing, in my submission, that has built within it the proposition that the order hasn't yet been fulfilled, I suppose, such that it's premature to bring contempt proceedings. So it is an election, my submission. And that was the view of Mr. Justice Cook when he said, and perhaps I can hand this up. So what we're providing there, my lords, my lady, is an extract from the transcript of the Part 72 hearing.
Where do you suggest we
71.
put this?
Towards the end, at the end of the supplemental hearing bundle, I'd suggest. Perhaps we could go to internal page numbering, page 217, which I think will be page 122, using the numbering that you have at the bottom.
Sorry, which page?
Page 217, using the internal numbering of the transcript.
So which bundle?
So I was proposing that this goes at the end of the supplemental hearing, supplemental bundle.
Right.
Which internal page, please?
217, my name. If we go to line 9, line 7, you'll see that Ms. Delaney was speaking. And you'll see line 9, she said, would you just give me a moment? And then she said, my lord, I have no further questions, but I do to raise with your lordship the question of contempt and committal. So I don't know if you wish to release Mr. Vick or you wish to keep him, or if your lordship has any questions. Ms. Justice Cook said, I have no questions. Mr. Laney said, my lord, I don't know if you wish Mr. Vick to stay in the witness box for the moment. Mr. Cook said, entirely a matter for him. I think if you've finished all the questions you would like to ask, I have finished my questions. Thank you very much, Mr. Vick. So I think he left the box. And then you'll see at the top of the next page, on the right-hand side, well, if you're preparing to make submissions to the effect that Mr. Vick has failed to obey the terms of Mr. Justice Tier's order, I would need that to be properly formulated.
So do we need to look at 218, what Mr. Laney was saying?
Oh, sorry, yes,
before
sorry,
that?
right. Yes, you're absolutely right. Yes, 217, then down below it. Thank you, my lord. Perhaps you could read lines 2 to 10. In fact, perhaps at the bottom of that page.
Yes, how far do you want us to read it?
If you could go on the right-hand side at the top on page 219, if you could read what Mr. Justice Cook says between lines 1 and 12.
Yes.
And you'll see then Ms. Delaney said that she understood, my lord, I completely understand. She gave an example of what she said Mr. Vick had said had been dishonest. And she says in line 22, and we have got a list of about 20, so my lord, it sounds as if your lordship might be prepared to adjourn consideration and make directions for a further hearing, and we will formulate. Mr. Justice Cook said, the technical position today is that we have had an examination of means of a former director of the company as the means of the company in question. If you want to make an application of any kind, it seems to be in relation to enforcement or in relation to contempt of court. I think that needs to be properly formulated on notice.
So, having been told by counsel at the bottom of page 218 that there is a third option of adjourning the hearing, the judge seems to discount that as a possibility.
In my submission, no, because what you've just seen is that Ms. Delaney then, when the judge had, after Ms. Delaney had raised those, he said at the top of 219, well, if you're going to make a submission of the effect he's failed to obey the terms of the order, I need that to be properly formulated. And that is then when Ms. Delaney said and gave her examples of 20 or so, well, she said they have 20 or so. So they were dealing here with the contempt route.
Well, they were dealing here with the possibility of an instantaneous application for contempt under the short form procedure rather than a long form procedure.
Potentially, yes, my lady. And what Mr. Justice Cook then said, and the point I was just reading at the top of 220, is that we've had this examination. If you want to make an application of any kind, and I think when he says it seems to be, what he means is it seems that the application that they're proposing is in relation to enforcement or in relation to contempt of court. I think that needs to be properly formulated notice. I need to have it spelled out with the skeleton argument and everything else, so I have opportunity to consider it against all the documents that I've seen for the first time today. And Ms. Delaney said indeed, and the judge also said, and indeed opportunity to reread the transcript. And then this is important. At line 20, Ms. Delaney said, the only point we wanted to raise in the lordship then is that we will make such application as appropriate, but may we have permission to serve CYK with the application on behalf of Mr. Vick. And so Mr. Justice Cook quite rightly asked, just tell me what the application is. So what is the application for which you want permission to serve by alternative service? If we, my lord, proceed with an application for committal and contempt, then that application to be served on Cook, Young and Keedon on the basis that they can bring it to Mr. Vick's attention. That is what we're asking for. So there was then quite a lot of debate about whether it was appropriate to be making such an order. Mr. Cogley, on behalf of Mr. Vick, opposed it. And I think where I was going to take you then is to line 15 of page 238, the last substantive page of the transcript.
3223 lines 8 to 8.
So I'm just looking at that. So my learned friend has asked if I show you something else. I'm just 223 lines 8 to 12. That's, I think, when Mr. Justice Cook said, Mr. Cogley, in the ordinary way, if an application is being made for contempt, it is done in a formal way with a proper application, so you get proper notice. So then going to where I was seeking to take you towards the end,
238, did you say?
yes. You'll see that we had discussions about bundles in line 15. Mr. Cogley said, I think it follows, my lord, as well. I don't know whether one asks for these things in this forum, but that Mr. Vick is released. Obviously, we want to speak to him, so we want him to be released from being on oath. I think it follows. And Mr. Justice Cook started saying, well, his termination, and Mr. Laney confirmed he has been released. And Ms. Cogley says, what I didn't know was whether there was something tucked away in part 71. And Mr. Justice Cook said, his examination has been completed. If it hadn't been, there wouldn't be an application of the, I think that must be of the sort, being made. It would be continuing with more questions to be asked. Yes, of course, thank you. So the point then is that the examination was completed. The bank said, we have no further questions. Twice. The bank said, he can be released. Has been released. The bank identified that there were options. The bank made clear that the application that they were actually proposing to pursue was one in contempt. Can I just address this one point about retrospective adjournment? We say that once examination has been completed, it's been completed, a hearing, which is what it was, has been completed, it's been completed. You cannot, in my submission, retrospectively adjourn a hearing. If it's finished, it would mean determining that the hearing wasn't completed when in fact it was. And that's a principal point, and it would, as a matter of practice, or in the facts of this case, be wrong because of the rewriting of history by granting a continuation retrospectively 11 years after the event, which the bank didn't seek, which it hasn't even applied for today, particularly when there's been the entirety of the contempt proceedings, which we say are can't be ignored. And so what we say is that, as was exposed in the questioning yesterday, having a new order which required Mr. Vick now to answer new questions, not limited to what he knew in December 2015, would be creating, in substance, a brand new obligation, brand new order.
So too would extending the time. Suppose you get this very often in relation to affidavits of assets, let's say, in freezing order. We don't require people to come back and verify what their assets are constantly between that date and the date of the hearing. They have to disclose their assets, sometimes at a past date, but generally at the date that they comply with the terms of the order. So they're ordered to provide an affidavit of assets within 7 days, and they come back and they say, we haven't been allowed enough money, we've got to take instructions, it's all very complicated, can we have a further 28 days? The answer is yes. Now, the effect is that the extension of time is asking them to identify their assets at a later date than that which was identified at the time of the original order. But is that not exercising a power which is a case management power pursuant to the incidental to the original freezing injunction by extending time?
What it isn't doing is retrospectively adjourning a hearing.
No, but you're on the point about whether the effect of the new order
Yes.
is to require them to do something at a later date than that which they were previously ordered to do.
Yes.
And that is the case in relation to an affidavit of assets But that doesn't prevent it being a case management decision incidental to the exercise of the original jurisdiction, original power, does it?
Well, that's a case management decision. This, in my submission, that's different in substance to what this is, which is after the date for compliance of doing the thing that he was ordered to do has been and gone, now recreating or creating a brand new different obligation which the court has no power to do.
No, I'm just on the narrow point,
Yes.
really, as to whether the fact that the effect of a new order is to give information at a different,
Yes.
information held at a different and later date, is itself anything which, although I know it was I who raised it yesterday, really casts any very great light on whether what one is doing is exercising an incidental power or a new power.
My submission, it doesn't really advance matters,
No.
because of course the court's probably got the power just to make the order. So whether it's whether because you don't raise the sort of question we've got here, which is where the person is not a director and all those sorts of things. It is why we don't see it discussed in those authorities that I'll come on to, that sort of thing. But can I address you then on the powers that the court identified in the CPR? The court identified CPR 3.12D, which is, so these of course are part of the court's general case management powers of case management, and they're subject to other rules, of course. Now, D is to require a party or a party's legal representative to attend the court. Now, in my submission,
Just for our benefit, I've got them printed out, but we sadly the public service doesn't pay for white books in court anymore, and we haven't brought them. So, we do have them.
We've got old ones.
No.
I've got it online.
But just helpful to read out the subparagraphs as you're going. Is all I'm saying.
so CPR rule 3.12D,
To require a party or a party's legal representative to attend the court.
yes. Now, these are part of the court's general case management powers. My submission, they're not powers designed to effectively determine substantive rights. That might echo what was said by Lord Justice Cotton in the case that was quoted in the GFN decision. We submit this doesn't apply. The discussion in the White Book, which the court I don't think has,
My lords, I've got some copies of the lordship in the ledger.
That would be very kind, thank you.
it's very helpful.
I've got that.
I think the Justice Popplewell's already got one.
Just here, thanks. Thank you.
I take it those are extracts from the White Book.
Yes.
So you have the notes. I'm grateful. Thank you. Could I ask you just briefly to look at the notes at paragraph, if you have them, 3.1.5, which is page 77, volume 1. Just to give and in the second paragraph, give some examples. If it considers it appropriate to do so, the court may also require the personal attendance of a party, in addition to that party's legal representative. Such a direction may be appropriate having regard to the overriding objective, see above, that the court wishes to facilitate settlement if the court takes the view that the case before it is one which the party should strive to settle. Such a direction may also be appropriate if the court wishes to ensure that the party knows and understands the matters in which the claim is being conducted and the possible consequences thereof. Making a redirection for the personal tenants of a represented party may be appropriate where the court presently considers the approach being taken in the conduct of that party's case is unrealistic. An order for personal attendance will usually be appropriate where the court has made an order for early neutral evaluation. If an order is made which simply directs the party to attend, that party may attend either in person or by counsel. I think the Falmouth House case may be a decision of my Lord Justice Nugee.
It was, yes.
And there's some later reference to that. Now imagine such an order could be made, an order requiring Mr. Vick to attend. My first point is that this is about case management. This isn't about determining.
Do you accept he's a party?
I don't, for the reasons that my learned friend will address you on in the question of service.
Yes.
But an order could only be in order to attend court. So let's say such an order were made. How is it fulfilled? By attendance at court. This is not an order, a power that gives the power to order Mr. Vick to answer questions at court. And linked to that, of course, is the point which my Lord Justice Nugee made in the Falmouth case, that in ordinary litigation, there's not a general power to order a party to attend to be cross-examined. Of course, in our situation, we have a specific power at Part 71, which gives a specific limited basis on which someone can be ordered to give information. This power, in my submission, in this rule, can't be used to effectively make an order that couldn't be made under Part 71.2. It doesn't even allow, as I said, to ask questions, how to answer order questions. And that's the point I'll come back to, that where there's specific provision in the rule, the general rules don't supplant it. There was also the reference to 3.12e, hold a hearing and receive evidence by telephone or by using other method of direct oral communication. My submission, similar points arise. This is about the court having the power to give, in my submission, arrangements for the conduct of a hearing. It might say it will hold a hearing and it's prepared to receive evidence by telephone. That is not the same, in my submission, as compelling someone to give evidence, still less to provide information. I've already made submissions in relation to 3.12a, which my learned friend raised about extending time for compliance with court orders, that's not actually what they're seeking. What they're actually seeking, what they need to seek, is an order for a new hearing. And of course, if what one were doing was retrospectively varying the date for compliance, that would mean that there was no breach.
Well, I'm still having difficulty with that. Can you not extend the time for compliance with an order, whilst at the same time recognising that there has been previous non-compliance?
In my submission, if the effect of extending compliance is it takes effect as a variation of the order. If the order says you must do this on this date, and then you say actually you must now do it by X date, what you're doing is changing the first order.
You're just extending the time for compliance with it. It's not the same.
I can see that if you extend the time for compliance before the first date arrives,
Yes.
well,
Yes.
then that's fine. That you're not in breach, because by the time the first date arrives, it's no longer the effective date. But once you've failed to comply by the original date, you are in breach. That's a fact, and it's a point you made earlier. You can't rewrite history. You can't say it's not a fact. You did fail to comply with a court order requiring you to do it by X. If the court then says, well, you didn't do it by X, I'm going to give you an opportunity to do it by Y, is that not an extension of time?
Well, if one takes the example of when there is an order to do something by a specific date, and the court says, I vary my order, you now must do it by this date.
Yes, but the language of 3.1 is not vary the order. I mean, there is a general power to vary the order, which is 3.17. But extend the time for compliance, even after the time for compliance has expired. That's exactly the scenario in which you get to the time for compliance, you haven't complied, you're in breach of the order, and the court nevertheless can extend the time.
Because you're extending it.
You extend the time, give you a second opportunity to comply. That doesn't, it seems to me, take away the fact that you did fail to comply with the order as it originally stood.
The critical word, my lord, in my submission is extending, not giving a new time for compliance. So you are extending it, so you're stretching it. So that means that that date has now been moved. That's my submission.
So in the failing to build the wall case, you say if the court sets a new time for building the wall, can't then proceed against the defendant for contempt for failing to build a wall by the first date?
No, it depends what the court does, because if the court has a jurisdiction to just make an order afresh, and it's the subsequent order things, then of course you can. The court says, do this today. But if what the effect is actually, if the only power you have, we said this isn't really case management, but if the only power you have to do is to effectively vary or extend the earlier order, then that is the consequence. And that's why it's not available here.
Right.
Are you going to look at little p or not?
Yes, I'm going to go to little p, my lady. Make any other step or make any other order for the purpose of managing the case and furthering the overriding objective, including hearing an early neutral evaluation with the aim of helping the parties settle the case. Now, I think I'm imagining that you have the notes to paragraph 3.1.13. I think this was a point made by my learned friend yesterday, that it's the second sentence. As to procedural matters, 3.1.2 he codifies or at any rate duplicates the court's inherent jurisdiction to make orders which it is necessary to make if the court is in fact is to act effectively. So if this is, and that's what my learned friend submitted this is, if this is effectively a procedural codification or duplication of a court's inherent jurisdiction, then in my submission that does engage the principle that a party cannot get around the procedural requirements of a particular rule by relying upon the inherent jurisdiction or general case management powers. It's the Van Hoogstraten case. I only need to show you one, I'm sure you're familiar with it. If I just show you briefly, it's in the authorities bundle at tab 9. Particular paragraph is paragraph 76, page 215. The position pre-CPR, therefore, was that the inherent powers of the court could not be invoked to do something which was inconsistent with the rule. Thus, if a rule gave a wide discretion to the court to decide whether or not to make a particular order, the court could not exercise its inherent powers to make such order ex debito justice as if it had no discretion, or a discretion which could only exercise one way in accordance with the rules.
Well, that's dealing with potential conflict. So if the inherent, if the rules cover it, you follow the rules. No point in using the inherent jurisdiction if it's covered by the rules. It would be wrong to adopt a different approach. But if you've got duplication between the inherent jurisdiction and the wide case management power, then it suggests that there's a power to do something, doesn't it?
Well, our submission is that what we have is rules 71.2, which governs the field, occupies the
Oh,
field.
that's the point, that the specific overrides the general.
Yes.
Yes, get that point.
And we actually have sorry, I was going to also show you paragraph 78, which I'm sure you're familiar with. In our judgment, therefore, where the subject matter of an application is governed by rules in CPR, it should be dealt with by the court in accordance with the rules, not by exercising the court's inherent jurisdiction. You can read the remainder of that paragraph.
So is this tantamount to a submission that you don't use the inherent jurisdiction to shore up deficiencies in the rules or perceived deficiencies in the rules?
It's the submission that there is neither inherent jurisdiction nor a CPR case management jurisdiction to do something which you can't do under part 71.2.
I think that is more or less what I was.
Yes, it is. I think that's fair.
But does it follow from that But there wouldn't even be a power to adjourn the hearing.
No, CPR Part 71.2 actually specifically recognises there can be an adjournment. 71.7. But what we're dealing with here is a different issue, which is the power to order a director or a person to give information. And that is, as we know from Masri number 4, not something that exists at common law as part of the court's inherent power. The power to do that only exists by virtue of the rule, 71.2.
Sorry, I'm just going back to your 71.7.
Yes.
I understand your answer to that. Perhaps my question wasn't very sensibly formulated. If before the time for the hearing, the date is that there is an extension of time, what is said to be an extension of time, no power to do that under the case management rules.
That was what happened in this case.
I think I would, well, certainly there's power to adjourn. I think we would accept that there's a power to vary in that limited sense. But what there isn't a power to do is after the date for compliance and after the order is effectively, the date for compliance with the order has gone, is then afterwards
But
to vary it so as to create
I know that's your submission,
Yes,
but I'm
that-
just testing the proposition that there is no room for any of these case management powers or the inherent jurisdiction of the court when what one's looking at is something which is governed by 71.2, so that if once the original order has been made and at that stage it can validly be made, but at a later stage when one wants to extend the time, you couldn't make a 71.2, you can't invoke these powers. And if you're right about the Hoogstraten point, then it's difficult to see how you could set a new date.
Well, in my submission, what one has to look at is whether what is being sought. I'm not suggesting that the case management powers don't apply at all. What I'm saying is the case management powers don't enable the court to do what is being sought today, which is not to just adjourn the date in advance. It is to make an order, the substance of which is covered by 71.2. It is to create a brand new obligation for attendance at a new hearing to answer new questions that aren't even limited to 2015.
I suppose it was as in the original form to attend on a new date to answer the very same questions, but actually it was the one that Mr. Justice Cook made in 2015, varying the date from September to December. If you're right, that's the same arguments would apply, wouldn't they?
Sorry, my lord, I
If
didn't.
you what Mr. Justice Cook was doing in whether you call it extending the time or varying the order, was saying in September, when it must be the case that Mr. Vick was no longer in the country, you must attend not in October but in December.
Yes.
Right.
Not creating a new obligation. Just as adjourning it is not creating a new obligation, it's not creating an obligation that isn't already under the order. Once we've gone past...
But Ms. Delaney would say, nor is the order they're seeking. It's seeking to have him answer the questions that he was ordered to answer in the original order.
But it isn't.
Or now a subset of them.
But it isn't even that, because if she limited it to that, she recognises there's no utility to it. What she is asking is for an order that requires him to attend again, to now answer questions coming up to date. That is a new order.
Well,
if my learned friend,
I think we've already
yes.
debated
Yes.
whether up to date makes it a different order. But anyway, you've seen my concern about whether the Hoogstraten point takes you too far, as it were.
Would it be a more satisfactory way of formulating your point to say you can't use general case management powers or the inherent jurisdiction to subject somebody to an obligation that you couldn't subject them to under Part 71? Is that really what you're saying?
Yes, I think that's.
Because that would cater for being able to use the case management powers
Yes.
to manage
Yes.
the Part 71, but not being able to use it to impose what you would characterise as a fresh obligation.
Yes.
If you're right on that, then it just collapses back into the same question, which is whether what we're being asked to do is all part of the original Part 71 process, or whether it's a wholly new Part 71 process, which is the question, because everybody accepts that Mr. Vick's no longer amenable to a new Part 71 process.
But my lord's formulation would also have the consequence, I think, that in the example I gave you, there wouldn't be power for Mr. Justice Cook to vary the date from October to December.
No, that would still work, my lord, because what you're
Because
not...
at the time that he was making that order, there was no 71.2 power to order him to attend on the December date, because he wasn't in the country at that stage.
What the court is doing there is extending the date, or effectively extending the date for the compliance of the order that the court's already made. That's not creating a new obligation, that's varying that obligation, I suppose you might say, which is different to after the time for fulfilment of that obligation having gone, to then make an order which now creates a new post-event obligation. That's the difference. And that's why in a normal case, you'd have an adjournment. You might have the contempt powers, which were options here. Contempt was utilised. If the director is still in the jurisdiction and still a director, you can get a new order. But that's, in my submission, really the nub of it. I was going to show you, sorry, I was going to show you an authority just making the point that the general rules do not, general words do not derogate from the specific words in terms of the CPR. I'm not sure if I need to. I think it's, yeah, my lady shakes her head. I hoped I didn't.
On that proposition, yep.
Yes, thank you. Can I address you then on, very briefly, on the issue that was floated by my learned friend already yesterday, that you might permit the bank to amend its application? No. Court has a point well in mind that the case management powers were not identified and didn't form any part of the bank's case hitherto. It made its application before the commercial court on a particular basis. My client cross-applied to strike it out. We proceeded to a hearing where the bank proceeded to seek its order. In fact, at that hearing itself, the ground shifted somewhat. The bank sought a revised draft order. It made an oral application for alternative service. The judge delivered a careful, reserved judgment. The bank sought permission to appeal, and the judge didn't seek to raise this then. The bank then renewed its application for permission to appeal. It was required to set out its grounds for appeal. There's a time for doing that. There's a time for appealing. The grounds for appeal didn't raise any of those arguments. So it wasn't in the appellant's notice, wasn't in the bank's skeleton argument. Even today, the bank hasn't prepared draft revised grounds of appeal and sought permission to amend its grounds of appeal. And in my submission, it would be wholly improper for the bank now to effectively be permitted to amend its application. My learned friend just suggested all she would need to do is amend her application, but there's a whole suite of issues, as I've just identified, that flow from that. And of course, the judge decided the application on the basis that it was made before her. To say that she was wrong to have decided an application on the basis it was made before her because she didn't consider a basis that wasn't advanced before her, my submission just illustrates why it's not appropriate to amend the application in this way. And it would be wholly unfair to my client. And questions, at the least, of Henderson type abuse of process might arise. I've not had a chance to properly think those through, but if a party has proceeded for an application on basis A all the way through, and then says, actually, can I have a second bite of the cherry by now arguing it on a different basis, still less in this situation, without proper notice, just raising it orally, my submission wouldn't be, and shouldn't be permissible. The hearing below wasn't a dress rehearsal. And so my submission, the shifting of the ground shouldn't be permitted. Now, to a large extent, because of the way that I've been addressing things, I've covered a lot of what I'm going to cover under ground one. So I'm going to try to avoid repetition as far as I can, but I did want to take the points head off. So apologies if that means that now I'm a little bit jumping around in what I'm.
It's our fault for taking up so much of your time.
I was trying to find a polite way of suggesting. No. Now, as we know, the bank relies upon it's called the court's power to make what I will describe as further or supplemental orders, so as to make another order effective. I think my Lord Justice Nugee put it yesterday to help with the first order. And it says that the order it seeks is within that jurisdiction. And as regards the question whether there are any limits on the court's power to make orders against a director or a person who is abroad, the bank submits that essentially that there are no such limits once the court has in personam jurisdiction. You can see that in the bank's supplemental skeleton argument, which is at tab 6 of the core bundle, paragraph 2.1, last sentence. If, as DB contends, the order it seeks is incidental and or ancillary to the Part 71 order, then any limitations on the court's power to make an order requiring Mr. Vick to attend for examination that might apply if the court did not already have personal jurisdiction over him are irrelevant. It says that similarly, last sentence, paragraph 7. Any limitations that might apply to the court's power to require a foreign company director to attend an examination absent existing personal jurisdiction over him are irrelevant. I'm going to very quickly as I can trace the contours of the jurisdiction that's being relied upon. I don't think I need to go into some of the cases that my learned friend took you to, in particular the decision in Beckor and Bilton, which was the first authority, where that was the case where freezing order had been made and there was a subsequent application for disclosure of assets, and on the facts the Court of Appeal said it's not an appropriate order to make. And that was where Lord Justice Ackner said at page 22G in the authorities bundle, to my mind there must be inherent in that power, which was the statutory power, the power to make all such ancillary orders as appear to the court to be just and convenient to ensure that the exercise of the Moravian jurisdiction is effective to achieve its purpose. And we saw that there's no general residual jurisdiction for the court to make whatever order is necessary to ensure that justice be done. Now, it's of course well established that when the court makes a freezing order, it might at the same time or later make an order for disclosure of assets as an ancillary to the first order. And that is, of course, we'd say uncontroversially, an order which is designed to help to make the freezing order effective. And we say an order in such circumstances will of necessity be of a different type, a different order, particularly if it's made at the same time. It would be nonsensical for the court when making a freezing order to say in paragraph 1 freezing order, paragraph 2 freezing order. And that was effectively one of the points that the judge made at paragraph 100 of her judgment. And likewise, and this is in the McLean case, McLean-Watson case, one doesn't obtain an order for a payment of a sum of money and a supplemental order alongside it for the payment of the same sum of money. It's not a case or a situation when one's thinking about how this jurisdiction is evolved, where the court is being concerned with being asked to make the same or similar order again. It's in my submission, it's hard to see how it would be necessary so as to engage the jurisdiction in order to make the first order effective, to make it again. And that's why, logically, to the extent that there is inherent in a power to grant relief, a power to make supplemental orders, such supplemental order has to be necessary to make the first order effective. Just pause there to note then a couple of points. There are necessarily limits. The first is limit as to the scope or the application of this jurisdiction, if you want to call it that, in the first place. It's a precondition to the existence of the power that there is some necessity to make the further order, to make the first order effective. So in another way, if order 1 and order 2, if order 2 is not needed to make order 1 effective, then there can be no power to make that further order. And when one thinks that the way it's formulated is, and we saw it in the Beckel case, it's inherent in the originating power to make a further order. So in our case, is it inherent in Part 71 that the court can make this order? And we say, and I'll come back to later, the power to make the Part 71 order derives from the rule itself. That originating or source rule or power does not permit the court to make orders against a director who is out of the jurisdiction. But my learned friend's case, of course, is nonetheless inherent in the power to make a Part 71 order is the power to make exactly such an order. And so in that sense, it's being said that this inherent implied power is more expansive or greater than the source power in which it is said to be inherent. And we say that's unprincipled and wrong.
I'm sorry to keep interrupting you, but if you're right about that, then Mr. Justice Cook couldn't have ordered him to attend in December.
We say that's not right.
But how do you reconcile the two?
Because of the point I made before, that when Mr. Justice Cook made his order, he wasn't making a Part 71.2 order. There was an existing order, which he was effectively varying, but it wasn't creating a new obligation. It's my point about once the obligation has been and gone, and the time for fulfilment of it has passed, as has happened here, to make an order now is to then create the obligation afresh.
Thank you.
So the first limit is the application of the ancillary power, and bearing in mind its source is to be implied out of perhaps the source power. The second is that there must also be still limits to what this ancillary power permits. In my submission, it would be wrong to say that, well, because a proposed order can be said to be helpful or in enforcing the first order, that the court has power to do it. So we always say that making order 1 does not produce or carry with it some unlimited and unfettered further jurisdiction to make whatever order the court conceives of, just because it might be said that in fact that will help in procuring compliance with the first order. So an example, where there's been an order for a party to pay money, the debtor doesn't pay. So you've got an order for payment. Doesn't mean that the court has a power to then say that the debtor goes to prison. We've got the Debtors Act 1869, so we do not have debtors' prisons. Now that's a statutory limitation, but of course there must be all manner of other limitations. So again, an example, if a judgment debtor needs medical treatment and doesn't pay the judgment debt, it might be said, well, if an order is made saying that they can't have access to the NHS, that's going to encourage them to pay the money. It will be procuring compliance with Order 1. But my submission, that doesn't mean that the court has power to do it. It's not just an open season as soon as there is an implied, as soon as you've made Order 1. There has to be limits. And we say that's self-evident. And that takes us to the decision in Masri number 2 from the Court of Appeal. My learned friend referred to this in their main skeleton argument, paragraphs 40.3, which they said recognise and confirm the principle, which they say is found in Beckel, McLean, Watson. However, in my submission, what actually comes out of Masri number 2 is an important point, that even if the court has in personam jurisdiction, there are nonetheless potential limitations upon its power to make orders. And in that particular case, where there are international implications and the question of subject matter jurisdiction. And what I'm going to take you in a moment, but in terms of the highlights, what it establishes or confirms is that the establishment of in personam jurisdiction is not the end of the inquiry. And contrary to what's suggested by my learned friends, where they say it's irrelevant once the court is in personam jurisdiction, whether there are principles about making orders against people out of the jurisdiction who are akin to witnesses, we say that actually those are very relevant still to the exercise of whatever power the court has. So can I take you to Masri number 2? It's in the authorities bundle at tab 7. Decision in the Court of Appeal. It's a case about appointments of receivers, amongst other things. Lord Justice Lawrence Collins gave the main judgment and was agreed by Lord Newburgh and Lord Justice Ward. You probably have some familiarity with the ultimate fact, the underlying facts, that the judgment creditor, Mr. Masri, succeeded in commercial court action. He established that he had a 10% interest in the judgment debtor's own 10% interest in an oil concession with exploitation of oil in a field in Yemen. And there was over $55 million owed, that's paragraph 1, and as pointed out in paragraph 1, which is at page 118 of the bundle, or 459 of the report, I believe. The judgment debtors, who are part of a substantial group based in Lebanon, have not paid the judgment debt, have made it clear that they will resist payment and commence proceedings in Yemen for declaration they're not liable. In the first instance, Mrs. Justice Gloucester appointed receivers in respect of the interests of one of the judgment debtors, a Lebanese entity called CCOG, in respect of revenues from the oil concession. And she also made a freezing order restraining CCOG from disposing of its interest in the concession and selling oil otherwise than in the ordinary course of business. That's paragraphs 3 and 12 of the judgment. She also ordered the provision of an affidavit of assets. I'd like to turn you to the discussion in section 4 of the judgment, which begins at page 29, sorry, paragraph 29, so page 123 of the bundle. Which is entitled Receivership Order and Subject Matter Jurisdiction. In paragraph 29, this part of the appeal concerns a question whether, even if the court has in personam jurisdiction over the defendant, it is appropriate for the English court to make an order for the appointment of receiver in relation to foreign assets. And then you see that subheading Subject Matter Jurisdiction. And perhaps if we can go to paragraph 31, having referred to the some US authorities, it said that it used to be said that there was a presumption that Parliament did not design its statutes to operate beyond the territorial limits of the United Kingdom, but nowadays the presumption has little force and simply a matter of construction. But even where legislation is construed to apply without territorial limitation, the question whether the matter has a sufficient connection with England may be a highly material factor in the exercise of the court's power, as for example under sections 238 and 239 of the Insolvency Act, transactions undervaluing preferences, which Mr. Justice Hoffman characterised as subject matter jurisdiction. And if we go forward to paragraph 34, having referred to the decision in McKinnon and Donaldson, it said that case, like in Paramount Airways, shows that what may be a sufficient connection with England to justify an order will vary with the circumstances. And it's the last sentence in this paragraph. What it says is that any power or discretion must be exercised in accordance with internationally recognised principles on the limits of the exercise of discretion. Paragraph 30. Consequently, the mere fact that an order is in personam and is directed to someone who is the subject to the personal jurisdiction of the English court does not exclude the possibility that the making of the order would be contrary to international law or comity and outside of the subject matter of the English court. Sorry, I inserted an of there. Outside the subject matter jurisdiction of the English court. Paragraph 40, just under the heading Societe Aram Shipping, there's then a discussion of that case. We don't need to look into that because what's relevant for our purposes is there's a helpful summary of the relevant propositions given by Lord Justice Lawrence Collins at paragraph 47, page 128. The following propositions can be derived from this important decision. First, it is not permissible as a matter of international law for one state to trespass upon the authority of another by attempting to seize assets situated within the jurisdiction of the foreign state or compelling its citizens to do acts within the foreign state's boundaries. Second, it would be an exorbitant exercise of jurisdiction to put a third party abroad in the position of having to choose between being contempt of an English court and having to dishonour its obligations under a law which does not regard the English order as a valid exercise. Third, this
Excuse.
Excuse. Let me put my glasses on. Thank you. Third, and perhaps most relevant for us, an in personam order against a person subject to the English court, subject to the English jurisdiction, may be contrary to international comity. There's further discussion and
Yes, well, what this passage shows is that having in personam jurisdiction isn't the end of the matter.
Right.
There may be circumstances in which that jurisdiction is not exercised for various good reasons.
right, and we say that that leads to the effectively our respondents' notice point, and this is the answer to my learned's friends, where they say once you've got in personam jurisdiction, everything we say is irrelevant without the international effects of the order. We say that's not actually correct. So
But why, I'm stop interrupting you. Keep going.
now, of course, Masri number 2 was not a case about summoning individuals or witnesses to be examined. Masri number 4 was such a case. And I need to take your lordships to that, my lady to that. I don't think I need to deal with Masri number 3. My learned friend took me through it. That doesn't say anything further on this subject. Actually, before going to Masri in the House of Lords, it may be helpful to just address briefly what the authorities that my learned friend cited on remaking orders. Now, none of the authorities we've looked at so far involve the court in exercising its inherent implied jurisdiction to make the same order. It was always making a different order in order to help with the first order. But my learned friend says there's lots of authorities that show actually that same jurisdiction being used to make the same order again. And my learned friend submits in their skeleton argument at paragraph 48.3 it is clear at Court of Appeal and High Court level that contrary to the judge's incorrect conclusions, orders similar to or overlapping with the first order can be made as part of the inherent jurisdiction to enforce the first order. However, my learned friend accepted yesterday that when she said, that's not quite right, when she said, all that we can say is that the cases don't discuss the precise nature of the jurisdiction being exercised. And that's right. My Lord Justice Popplewell, you made the point when my learned friend was making submissions on the case of Wilkinson and Andren, where that's the case involving the daughter, where the court was making fresh orders. There's no discussion in there of any suggestion that this is exercising the jurisdiction that's discussed in the Beckor and the Claimant cases. And as you said, well, quite obviously, and we say it is quite obvious, that if the court has power to make an order of the sort it was making, then it's just making that order afresh. It doesn't give any illumination to the question that's before this court. So it's certainly not authority for a proposition that remaking the order involves exercising this, what my learned friends have called the ancillary or inherent jurisdiction. And the same applies to the Kamari and Jamal case, which I will briefly take you to, because that was cited in the Wilkinson case. Right? That's at tab 4 of the authorities bundle. Court of Appeal decision. Again, it arose in a domestic scenario. This was a case where a man, there'd been a divorce. Various orders were made in the context of ancillary relief, different to the ancillary jurisdiction we're talking about here. And then the ex-husband was wrongfully held to it was held, the Court of Appeal said he'd been held in contempt for the second time for breach of an order, which was wrongful, has already been effectively punished. But can I just show you briefly the facts? In the decision of Lord Justice Neal, which begins at page 78 of the authorities bundle, page 98 of the judgment. This is another case which demonstrates the care which has to be taken before orders for committal for contempt of court are made. And if we go to the next page, paragraph, page 99. What essentially had happened is that there was a dispute. This is at A. The ex-wife had prepared a list of property which she said belonged to her, and Mr. Jalal had done the same. There was a dispute as to who owned what. And then next paragraph, there was a hearing before a district judge. A declaration was made in respect to the ownership of certain items of property to the effect that they should remain the absolute property of Mr. Jalal, but there was a further order that Mr. Jalal should transfer to Mrs. Kumari within 7 days all the items listed on pages 1 to 8 of the list which had been exhibited to the exhibit. See 2 sentences on. It was ordered further that in default of delivery, Mr. Jalal should pay to Mrs. Kumari 2/3 of the value of the items, such values being stated in document attached to the order. No action was taken to comply with the order, or none that satisfied Mrs. Kumari. So she went back before the district judge. You'll see this is on this occasion, a specific delivery order was made, which did not give Mr. Jalal the alternative of paying a sum of money. The order was that within 7 days from the date of this order, at his own expense, Mr. Jalal should deliver to Mrs. Kumari all the property which had been ordered to be transferred by the order of 10th of August 1994. Now it appears that there was only partial compliance with that further order. That's paragraph G on this page. Nor did he pay. Yes, so a committal application was made, and Mr. Jalal was sentenced to 3 months in prison. You can see that
At the bottom of the page.
bottom of H, thank you. And then over a year later, Ms. Kumari made a further committal application saying that Mr. Jalal had still not complied with the order. That's at G over the page. As we go to the next page, so page 81 of the bundle, you'll see at B that Judge Harold Wilson gave a judgment, which is quoted from here. You can see from that so he said that the contempt continues, this is the last line, and is visited by a further term of 6 months imprisonment. So there was a further order, a further 6 months. Now the main argument on appeal was that Mr. Jalal had been ordered to return goods by a specific day. He had failed to comply with that order. That was a single breach, which was spent, and could not for that breach be sentenced again. And for our purposes, relevant is at paragraph 81F, where Lord Justice Neal said, where there is a dispute about property, a court can decide the question of title and can make an order for delivery up of the property, and identified where that can be done under the rules of the Supreme Court. And it says that it's necessary that the order for delivery must set out a date for compliance. In fact, in that case, there hadn't probably been a proper date for compliance. But what that makes clear is that there was a jurisdiction that the court was exercising. Its jurisdiction, when it made the specific delivery order, to make orders for delivery up of property. There's no suggestion in this case that what the court was doing was exercising some inherent jurisdiction based upon some earlier order to make this further order. There's just no discussion of it. In fact, in my submission, what this suggests is the court considered that the judge, when they made he made the second order, the specific delivery up order, was exercising the very original jurisdiction they had to make such an order. So that this authority doesn't, in my submission, lend any support to the contention that there are a host of authorities which establish that the court's ancillary power or implied power when it's made order one is used routinely or at all to make the same order or version of the same order. So that's the Kamari case. The Wilkinson-Adjan case you were taken to, I've already made the point, but it was made in argument yesterday to my friend, but it doesn't again suggest anything different to that which I've just said. Rather, in my submission, in that case, where the court was making successive orders, the logic is that a fresh order needs to be made, and it was fresh order was the expression used throughout to create a fresh obligation. The other authority my learned friend referred to was Rowland and Stafford, which was the extemporary judgment of Mr. Justice Johnson. And it's suggested in my learned friend's skeleton argument at paragraph 51.2 that this is direct authority that the court can enforce a prior order that has been breached by making a further order in similar terms. Judge, Mrs. Justice Popplewell, actually dealt with this authority in her judgment. Paragraphs 102, this is core bundle tab 10. Page 128. And as she held there, Rowland and Stamford was a very particular case, not be seen as laying down a useful principle. It then discusses what happens, and I should say that only one of the parties was even represented in this case. And she said midway through, in those particular circumstances, it appeared that the judge remade, or at least in part, the order that the contemnor had breached, so that the contemnor could be discharged, yet still be subject to the obligation to provide such documents and information as he had not yet been able to provide. It plainly turned on its own particular facts, nor is it apparent that issues as to the basis of the power to make the order were in play. That may well be in part because in that case such arguments were pointless. The court would presumably have had power to make a fresh order in similar terms to the order that had been breached. My submission is clearly right that a judgment, an extemporary judgment, when it's only argued on one side, where nobody actually discusses, no discussion in the judgment of the power that the court was being asked to exercise, it's not clear that it was even raised as an issue. So my submission clearly, as the judge held, doesn't stand for any proposition to support the case that's being advanced by the bank. And of course, the judge is likely right as to why it may not have mattered much, because it was a Norwich Pharmacal order that it's presumably likely to have been the case that a fresh Norwich Pharmacal order could have been sought and obtained. That then takes me to the committal order in this case, which my learned friend also relied upon as demonstrating what was suggested to be the proposition that making an order in similar terms to the first order is within this ancillary jurisdiction. It's plainly the case that the committal order was incidental to the first order. It's to enforce compliance with it. It's woven into Part 71. It's woven into the entire fabric of the legal system, I suppose. But the committal order wasn't a fresh order in the sense that my learned friend submits. It imposed a sentence. This was a point made, I think, by my Lord Justice Nugee yesterday. It imposed a sentence suspended on condition that Mr. Vick did certain things. And that was a point made by Mrs. Justice Cockrell in paragraph 117 of her judgment. It's substantively, in my submission, different to what the bank is seeking to create now. It's a fresh obligation, it's a fresh order, which it would then seek to punish itself with contempt proceedings if made. And so it is, the fact of the committal order doesn't, in my submission, support the bank's case. What it's seeking now is routinely ever granted. Now, in regards to the judge's judgment,
Are you still waiting to come back to Masri number 4? Or
yes, I think, sorry, I think actually I will come back to Masri number 4 in the context of the respondent's notice point. It's probably more helpful at that stage. Sorry, I ought to have said I'd made that decision. Leaving you on tenterhooks, I apologise. So paragraphs 72 to 77 of the judgment, which is in tab 10, the judge discusses the jurisdiction, recognises that there is this power, or a power, and discusses the various authorities. And I don't think my learned friends say that she got anything wrong there. What they say is she misapplied it. Now, at paragraphs 82 to 84, the judge rightly recognised that no de novo order could be made. So what the judge then went on to consider was whether what was being sought was nonetheless within the scope or ambit of the powers that the bank was saying could be relied upon. And if one goes to paragraph 91, there's the discussion for the judge of what is incidental, what is ancillary. Now, my learned friend sought to attack the judge's analysis there. As mentioned, what the judge is doing, and you can see this in particular when you see her reference in 92 to the authorities, is just illuminating what this jurisdiction is. If you don't have order 1, there's no basis for order 2. That's essentially it. So you need to have order 1, and to have this further order needs to be by reference to order 1. Otherwise, we're not even in the circumstance my learned friend says. And that's effectively what the judge is saying, that when the judge says something that exists by reference to something else, something which is secondary to or merely supportive of something else, or that has no functional purpose without the thing to which it is incidental or ancillary. And as mentioned, there's nothing wrong with that. If order 1 is made and then it's held that that order is ineffective for some reason, you wouldn't enable the court to use that as in my submission as a platform or a springboard to then get an order 2 to make order 1 effective, because it's illogical. So nothing wrong in the judge's reasoning here, in my submission. And that's why the judge then discusses the cases in 92, makes the point in 92 Roman 1 that what was being done there was disclosure to give teeth to a freezing order. That wasn't all, that was what's being discussed. Of course, it wasn't granted in Beckor. Plainly, that wasn't the same as the relief granted by the freezing order. It was something of a different nature. It was something that plainly facilitated the operation of the freezing order. She's right in her discussion of Masri, the incidental orders were similar, post-judgment receivership and freezing orders. And then she discussed the committal orders relationship with the 2015 order. And she made the point, of course, and this point I've just made, it's not identical to the order, and the distinctions I've already drawn. There clearly was an ancillary order in that sense, but there's nothing wrong with the judge's description here. Now, the judge goes on to analyse, in my submission quite rightly, the application that was originally being made, just as we saw in the Beckor case, well, actually I don't think I showed it to you, where the judge went through to analyse what is being made, what's the evidence in support of it, and concluded this is not being sought to assist in the freezing order. It's actually, so it falls outside the jurisdiction. The judge was right to have done that. But of course, what she then did was she, at the hearing, gave the bank the opportunity to suggest a different variation of the relief it was seeking. And she went on to consider that as well. Nothing wrong with that. That was actually to the credit of, to the favour of the bank to have done that. And what the judge said, having identified, as we've seen, the relevant principles, is analysed the matter from a number of different directions against that standard. And she rightly made the point in paragraph 95 that the order as originally sought was not one that was different in quality to the Part 71 order and in any sense complementary to it, was effectively a rerun of the original order. That's obviously not being sought anymore. The judge made the point that it's not that the order being sought wasn't a means of breathing new life into or enforcing the 2015 order. In my submission, that's right for the reasons I gave earlier, that the order had required performance on a specific date, and the order to attend to answer questions on a new future date is not procuring fulfilment of an order or an obligation that was required to be performed in the past and where that time has now passed. And if the order was made, it would not ensure that Mr. Vick attended the examination that was ordered in 2015. As the judge said, effectively in 97, the proposed order would create a new obligation to attend to be examined. And as she also said in 97, it wouldn't be a resumption of the 2015 hearing. All of that is correct. And the further examination would be carried out under this new order, not the earlier one. That's paragraph 97 as well. And in 98, the judge rightly said, nor could this constitute an adjournment. She said, the application not framed that way and could not be. The judge went back to that point in paragraph 115, where the judge said, adjournment to the original hearing is also provided for and would be ancillary. As noted, Deutsche Bank opted for the committal route in this case. Further post-committal examinations are not provided for by CPR 71. Now, in my submission, for the reasons I've given already about what the nature of the jurisdiction is, the judge was right. Now, my learned friends made much in their written case and already yesterday about a supposed misconception which was said to have heavily infected the judge's reasoning. It's said to be a fundamental error in what the judge said in relation to what the judge said much later in her analysis in paragraph 111. In my submission, that's an unfair attack. It's one which is dislocated from the substance of the judge's reasoning. When one looks at the judge's reasoning, the judge didn't say this would be an ancillary order had Mr. Vick not been fleetingly present. There's no part of the judge's analysis which is dependent upon this. And it's important to see what the judge actually said. So having been presented with a revised draft at paragraph 110, the judge said what is sought therefore is a clear subset of what Mr. Vick should have given but failed to do. On that basis, it was said to be ancillary. It was, of course, very tempting to take a broad view of the question in light of Mr. Vick's determined attempts to avoid complying with both the judgment of this court and also the 2015 order. That was the course which Deutsche Bank effectively urged. So what she was saying there is to take a broad view. She was saying that's what's being urged. However, despite that, it is important to ensure that the court does not take in itself an excessive jurisdiction. And just pausing there, that's absolutely right. You decide questions of jurisdiction by reference to principle. You don't work backwards, in my submission, from the conclusion that you wish to reach and then seek to find a jurisdiction. And then the judge said, perhaps particularly against a background where the original jurisdiction under the 2015 order was at the outer limits of the Part 71 jurisdiction, in the sense that Mr. Vick was only fortuitously in the jurisdiction at the relevant dates, and where it is clear no fresh order could now be made. So 2 points. It is obviously right, given the arguments we were making, that the judge needed to consider, when she was doing her analysis, the question whether no fresh order could be made. In fact, she didn't need to deal with it in her judgment. But it's also fair for the judge to say, in rebuttal to the bank saying, Mr. Vick is a serial contemnor, therefore you must find the power, to say, well, it's equally, I suppose, possible to say that he was only fortuitously made subject to the court's power. Either way, in my submission, this, what might be called a passing remark, perhaps it was prefaced with, certainly didn't infect the substance of the judge's reasoning. And if the judge is otherwise right, the judge is otherwise right, my submission. So it's a bit of a storm in a teacup in my submission. Now, given the points I've made in my submission, what the judge was right to do was to conclude that this was an order that was being sought, which effectively didn't involve a continuation of the examination which had been completed, didn't involve an adjournment of the original hearing, didn't involve making Mr. Vick going back in time to do something in 2015, but would create a brand new obligation to answer new questions untrammelled by the date in 2015. And the judge was right. The judge also went on to deal with double jeopardy at paragraph 118. Again, perhaps something of a side issue, because if the judge were otherwise right for the reasons I've said, this doesn't affect matters. But it is worth, in my submission, looking at what the judge actually said. The judge was here sustaining or scrutinising the contentions that the bank wasn't seeking in substance a fresh order. And the judge didn't misunderstand the double jeopardy principle. It's uncontroversial that if a new order is made, a fresh order, then that and breach of that can be a contempt. But the point the judge was making is you would then need a fresh order. But on Deutsche Bank's case, as the judge addressed, this was merely an order to ensure compliance with the first. And so the line that the bank was trying to draw, she found hard to maintain. Because, of course, if the new order was merely procuring compliance with the first order, so take the example of a freezing order where an order is made for disclosure of assets. You breach disclosure of assets order, that's a breach of that order. It's not a breach of the freezing order. You breach the freezing order, you breach the freezing order. You don't get a freezing order and then get a new freezing order because there's been a breach of the freezing order. And that's effectively what the judge was struggling with, is this idea that this order was anything other than in substance a brand new obligation that fell outside the concept of an order to give effect to an order which effectively required compliance 11 years in the past, or 10 years in the past, I think, at that time. So my submission, for those reasons, the judge was right for the reason that she gave. What I propose to do now is to move on to the respondent's notice point. I've already touched upon it I've addressed you on Masri number 2. There was at one point a procedural objection to that, but I think that's now gone. I think it's now accepted that this was argued below. I think it gave all the references to my supplemental skeleton. And as you've seen, the bank's case is essentially that once the court has in personam jurisdiction over the person, that's pretty much the end of the inquiry. And as we've already addressed, there are limits. There are limits to the jurisdiction, the implied jurisdiction. It doesn't give the court the power to preclude people from going to the NHS or just to throw people into prison just because it's made order 1. It's a power that needs to be carefully exercised. You've got to consider whether it is genuinely necessary to enable compliance with order 1. And when the court is considering exercising a power, particularly if it has international effects, then there are certain principles and factors that the court will consider in the
That comes into the justice and convenience of making the order, doesn't it, rather than the power to do it?
Sorry, my lady, which part comes into the justice?
Well, if you have a power to make a certain type of order,
Yes.
then obviously in deciding whether or not to exercise that power, questions of international comity, all that sort of thing will come into the equation. But as I understand it, what you're saying is that in deciding whether you've got the power in the first place, you have to consider international comity, and that's what I'm struggling with at the moment.
Well, whether one describes it as being a limitation on the power or a limitation on the exercise of the power, in my submission, the point comes to the same destination. I think we see that in, I think in maybe one of the Masri cases, that there were 3 different ways of putting it, whether it's a limitation on the existence of the jurisdiction, whether it's a limitation on the application of the jurisdiction. Sorry, I'll try and find the reference, but yes, I see the point. My submission, as a matter of analysis, it matters not. My learned friend would say it goes to, or my learned friend would now have to say that it at least goes to the question of whether it's just and convenient to make.
But in the present context, it must be a discretionary question, mustn't it? Because the same question would arise in the autumn of 2015 in deciding whether or not to set a new date, which was a date for attendance after Mr. Vick was no longer in the country. And so potentially engaged at that stage were matters of international comity and whether he should be forced to come before the court. Now, I think you say Mr. Justice Cook was at least entitled to extend the date or to vary the date or whatever it may be. But this is a principle which would have applied, and that's why I say it must really be, in the context we're describing, a discretionary question as to what is just and convenient, rather than a question of the power.
Perhaps not, in fact, my lord, thinking about it. Certainly it would come in there, but there is actually the more fundamental point that there is no common law power, we say, to make the order that's being sought. That's clear from Masri. The power to make the order sought is only statutory, we say, derives from the statutory code which is in 71.2. And that limits any inherent power that is parasitic upon that must be limited by the terms of the rule that creates the power. That's what we don't see in any of the authorities, because in none of the authorities was the court making making an order under a power and then being asked to make the order again, same order. So you don't have this discussion. But that's what's our case. The court's made the order under a source power, and now they want to make another order, the substance of which is beyond the source power. We say that it can't be that the inherent power goes broader to allows you to make an order that's more searching and far-reaching than the source power.
I understand
yeah,
that, and that
so
seems
that's
to be
my point.
that seems to be your main point on ground one.
Yes.
And just as a respondent's notice point, which is if there is a power, it can't be exercised because it's exorbitant,
Yes.
extraterritorially. Whether you say it's a curtailment on the power or whether it's part of the just and convenient, which was really where my lady was coming from.
That's fair. So it comes in at both grounds. I think that must be right analytically, given how the argument is developed. Yes. Masri number 4. It's in the authorities bundle, tab 10, page 225. We've Lords Scott, Roger, Walker and Brown all agreed with the judgment of Lord Mance. And Lord Mance's judgment, if we can pick it up at page 265 of the judgment. Sorry, of the bundle. 266. Just note in paragraph 5 that Lord Mance made the point the two judgment debtors, CCIC and CCOG, have manifested their intention to avoid payment of this judgment debt at all costs. So this was a case where there was significant judgment against those companies. They had manifested an unwillingness to pay. So it was a case where there was a judgment of the court. Enforcement of it wasn't being complied with. Now, my learned friends, of course, make much of what they say is the strong public interest in the enforcement of court orders. Nonetheless, the House of Lords concluded that despite this background in Masri, there was no power to make an order under 70.2 against the officers of the judgment debtors. If we go to paragraph 12, there effectively two issues were being run. First one was being argued on behalf of the judgment debtors that effectively it was an ultra virus argument that Rule 70.2, if it did apply in the way that was being said, then that was ultra virus because there was no power to do it, and that Lord Justice Mance didn't agree with that. And at paragraph 12, in discussing that issue, you'll see that he referred to the limitation on the court's power to enforce the tendencies of witnesses or find defaulting witnesses from the Statute of Elizabeth 1562 onwards. This has been regulated by statute and never extended beyond the United Kingdom. And then you'll see two sentences on the service of a writ of subpoena is still only possible under section 36 of the Supreme Court Act 1981 in respect of persons in one of the parts of the United Kingdom. The limitation of the court's power in this respect corresponds with the principle of international law summarised robustly by Dr. Mann in his Hague lecture, The Doctrine of Jurisdiction in International Law. Perhaps you might just read that.
Very well.
Thank you. At paragraph 16, Lord Mance went on to discuss the second issue, which was on the basis that Rule 71 wasn't effectively ultra vires, or Part 71. It was then the scope of the rule that was actually made. Now, in that decision, as you can see in paragraph 16, the presumption against extraterritoriality applies when considering the scope of CPR Part 71. You'll note in paragraph 17 that it said at C, there is nothing in CPR Part 71 to enable the court to summon a third-party witness who might have information about the personal judgment debtor's action. Corporate judgment debtor has separate legal personality and is not to be equated with its officers. They may have information about its affairs, but they have not submitted to the jurisdiction. Some, but certainly not all, officers of the company may for some purposes be regarded as alter ego. And that was then part of the reasoning in the Court of Appeal. And you'll see that is then said, but CPR Part 71 is not limited to officers constituting a company's alter ego, and the present order was not obtained, is not defended on the basis of any suggestion that Mr. Cowie was CCIC's alter ego. There was then discussion in the paragraphs which follow of two insolvency cases in Re Seagull Manufacturing and in Re Tucker, which we've got, I think, Re Tucker in the bundle. There were two different provisions under the Insolvency Act. One which enabled the court to require officers, or bankrupts, I think, to be examined, and one which required others. And it was held that one has extraterritorial effect, the bankruptcy, the one against the bankrupt, but not the one against others. And of relevance, at paragraph 23, the category of persons embraced by Part 71 is confined to an officer of the company or other corporation, on the face of it, probably only a current officer at the time of the application of order, whereas Section 133 extended unsurprisingly, since it dealt with the company being wound up, to past officers and some other closely connected persons. And you'll see that there's a discussion of what Part 71 is. Part 71 is concerned with obtaining information in aid of the enforcement of a private judgment. The public interest that those responsible for the company's state of affairs should be liable to be subjected to a process of investigation, and that investigation should be public in Re Seagull is absent. The universality of a winding up order, in the sense that it relates, at least in theory, to all assets wherever situate, is also absent. Private litigation is different. A fair and efficient legal system is, of course, a cornerstone of the rule of law, and it can be said that there is a public interest in the court getting to the bottom of litigation and ensuring that parties have means of attaining full information to enable it to do so. Yet the parties have no right to ask the court to summon witnesses from abroad for that purpose. While a judgment crystallises rights and establishes an unsuccessful defendant's liability, the court is still acting in aid of private rights after judgment. Continuing in paragraph 23, an important point made in the last line at E. Also, a few lines up, it said, there is a very clear difference between the importance of evidence for the trial of liability and quantum and for the enforcement of a judgment. A judgment which is mistaken because of a lack of full information or documentation could be seen as an even greater, could even be seen as a greater miscarriage of justice than the judgment which is not enforced because of the same lack. And then
let's just pause for a moment and see where we are on
Yes.
timing. You're not going to get to the end of this before 1 o'clock.
no, I'm not.
On the other hand, I am conscious that we have interrupted you quite a lot. And I don't know whether a shortened lunch and adjournment would assist and is available. If we started again at 22, would that?
That would be helpful.